Hello there. Hey, this is Bill O'Leary coming to you live here on this Thursday. And I'm coming live as part of a series we do every Thursday called Thirsty Thursday, where I go live and I talk about something I've come across, an issue, a topic, a situation that I see or hear about at my law firm. I'm an estate planning attorney and a probate attorney with Legacy Planning Law Group in Jacksonville, Florida. And so if you're thirsting for knowledge, you've come to the right place for sure. So today I want to talk about something that actually came up about a week or so ago, and it has to do with a limited power of attorney. What is a limited power of attorney? So before I do that, let me first define what a power of attorney is. A power of attorney, also known as a POA for short, it's a legal document that authorizes somebody that you name to manage your financial affairs for you. Let's say if you can't anymore. And so the person who gives the POA, who sort of signs the POA, that is the person that grants the power, is called the principal. The person who receives the POA, who is given the power to act, is called a couple different names: an agent, also referred to sometimes as an attorney in fact. Now, there can be one agent or attorney in fact acting at one time, or you can name two or more agents to act together at the same time. Although I will say to you, my very strong preference is to have one at a time and then sort of a succession or backup order rather than two people serving at the same time. Now, a power of attorney is controlled or governed by the law of the state where the principal lives, and the law of that state will have very specific requirements about what sort of defines and makes for a valid POA. Now, there are two general types of POAs. One is called a general power of attorney, which allows the agent, attorney in fact, to handle anything and everything that relates to financial matters, and this is by far the most common. The other kind, not nearly as common, but it's called a limited power of attorney. This is where the POA is tailored to allow the agent to only make certain types of decisions. For example, a power of attorney can be used to allow a person, let's say, to stand in your shoes and close a real estate transaction on your behalf, but that's it. They can't do anything else. Or maybe the agent can help you with a particular transaction or financial decision or a matter. Or I had a situation recently where the agent under a limited power of attorney was allowed to just handle the business affairs of a particular business if the owner became incapacitated. Just handle the affairs of that business, but not any of the owner's other matters. So again, allowing an agent to do just certain things, but not everything, is known as a limited power of attorney. A limited POA is usually limited, can be limited, I should say, for other reasons. Let's say a specific period of time, maybe to a specific event or for a specific purpose. So for this reason, a limited POA really only makes sense in certain situations. So for example, it would not be really a good idea, a good option, where you want the agent to have a wide range of legal authority to handle your affairs with very little restrictions. So then when would it make sense to give someone a limited power of attorney? Well, here are some examples where it may be a good idea. Let's say this: you temporarily need an agent to be able to act on your behalf. Again, you only need somebody for a temporary or short period of time, defined period of time, but not forever. Or what about this? Let's say you're physically not able to handle specific matters because let's say you're out of the country traveling for an extended period, or you're ill. So let's talk about the travel situation. Maybe you can authorize someone to help you with all of your financial affairs, but only for that limited time until you return home. Or let's say you're sick, or you're going in, let's say, for a medical procedure that's going to knock you out for a period of time. You can give a limited power of attorney to authorize someone to manage your financial affairs until you recuperate, get better. Then the POA stops. Or how about a specific transaction that you need help with, okay? So let's say you're closing on a house or buying a car and you want someone to be able to act sort of in your place to handle that for you. That limited POA can be limited to that transaction only, but nothing else. Or how about this? You maybe need help with certain transactions and you need help from people that are going to have a certain expertise or professional capability with specialized knowledge. You can give them a limited power of attorney over that transaction. And once the transaction is finished, the agent no longer has the legal authority you granted them. Now, a limited power of attorney, it is a legal document and it's a binding document once you sign it. And it should be carefully drafted to make sure it encompasses all the limitations you have in mind. So for example, in some states, unless you specifically say otherwise, a power of attorney, even if it's limited to certain activities, can still be in effect if you become incapacitated. You may not want that. And by the way, a quick word about the all-important decision on who to select as your agent. When choosing an agent to appoint, it's very important to find somebody who's trustworthy, who knows your wishes and is going to work, or she, in your best interest. And while doing so, is going to be fairly objective and sort of detached, be able to make those objective decisions. A capable agent will be responsible, will be fair-minded, and have strong organizational skills. By the way, just note this, that for a professional fee, you can have a professional take on this role. Now, each state's laws and rules as to what constitutes a valid POA and the responsibilities that are conferred on an agent, each state's law is different. And by the way, Florida has a very specific POA statute that we have to follow. So a power of attorney form has to be not only laid out in a certain way and include the right verbiage, but it has to be executed, it has to be signed, witnessed, notarized in a very specific manner to be valid here in Florida. So certainly this is not something you'd want to try at home. So if you'd like to know a little bit more about powers of attorney, limited powers of attorney, maybe general powers of attorney, and you want to find out if we can help, we'd love to talk to you. So you can go ahead and book a free 15-minute phone call. Real easy. There's a pop-up now that now appears on this video. Click on it, takes you to our scheduler. Pick the day and time that works, or go to our website. There's a book your free call button. Can't miss it. So basically, it's a chance to sort of get to know you, and we can tell you if we can help you. Hey, if you've enjoyed this video, do like it, okay? And to subscribe to our YouTube channel. We're putting more and more content up all the time. So, hope you've enjoyed this talk. Again, the subject of this talk, limited power of attorney, what is it? I'm going to give another talk next Thursday at about the same time, part of our Thirsty Thursday series. Same day, different topic. So if you're thirsting for knowledge, we'll quench your thirst. So Bill O'Leary signing off for now. Go make it a great day and make it a better world.